All right, so let's go ahead and do US v. Virginia. So the Virginia in this case is the United States suing the state of Virginia, but the state of Virginia because of actions which are taking place at VMI, which is Virginia's Military Institute. VMI was a public university, well, is a public university in Virginia that has a military type background. Its mission as it was charged in the 1960s was to produce quote unquote citizen soldiers, whether their graduates entered military or civilian life, no matter what. And at the time that this case takes place, only men were admitted to VMI, and of those men, only 15% went on to military careers. So this was, while a training ground for military careers, that clearly was not the overwhelming purpose of why individuals went to this school, because only 15% ended up actually going into military careers. Well, the United States government sues the state of Virginia, arguing that their male-only admissions policy was a violation of the Equal Protection Clause. And the district court finds in favor of VMI, and the Fourth Circuit ultimately reverses it, finding in favor of the United States. While this was going on, the state of Virginia proposed a parallel program, which they entitled the Virginia Women's Institute for Leadership. And it was located at a private school. So unlike VMI, which is a state school, this parallel program would be located at the private school, which the district court and also the Fourth Circuit Court of Appeals both gave their stamp of approval as okay. So the question in this case is whether the male-only admissions policy at VMI violates the 14th Protection Clause of the Constitution, and also whether the parallel program can be used as a substitute for the same goals. So there was a point in time, and this is important to know, there was a point in time where some of the programs offered at VMI were exclusively offered at VMI, but all programs at VMI could be taken at other state schools. At least that's what Virginia offered, so that it wasn't, VMI in itself was not unique. It did not offer any experience that could not be gotten elsewhere within the state. Justice Ginsburg writes the majority opinion in a 7-1 opinion. Justice Thomas doesn't take part. And Justice Ginsburg argues and writes in such a fashion as to invoke her 1970s litigator self, but through the opinion of the United States Supreme Court. She argues that the system itself in VMI that is used at VMI that excludes women is unconstitutional because, quote, women have no opportunity anywhere to attain the benefits of a system of education at VMI. It cites primarily Fontiero as its background. And Ginsburg goes on to say that the inherent differences between men and women we have come to appreciate remain cause for celebration, but not for denigration of the members of either sex or for artificial constraints on an individual's opportunity. She says that the sort of sex-based classifications that were once legal in Gossert existed to create and perpetuate the legal, social, and economic inferiority of women, and that because of this, we must apply intermediate scrutiny. We must apply the scrutiny test to every case that comes before the court that discriminates on the basis of gender. But what Justice Ginsburg does here when she invokes the intermediate scrutiny test is very interesting. So we remember that the initial immediate scrutiny test was articulated as a important state interest, that the state had to demonstrate an important state interest. When Justice Ginsburg invokes the intermediate scrutiny test, what she says is, we conclude that Virginia has shown no exceedingly persuasive justification for excluding all women from the citizen soldier training afforded by VMI. So she takes that important state interest and raises it almost to the strict scrutiny standard, which is a compelling state interest. Remember that before she joins the court, that the idea of intermediate scrutiny had been taken down in opinions, primarily by Justice Rehnquist at the time. And so she raises the standard in her writings significantly higher and invokes a much higher level of protection for women's rights. She goes on to cite Reed v. Reed, and when she addresses the parallel program, she argues that it is insufficient because generalizations about the way women are, estimates of what is appropriate for most women, no longer justify denying opportunity to women whose talent and capacity place them outside the average description. So very simply, the parallel program, not in terms of standards of acceptance into the program and not in terms of the type of education provided, was equal. So the alternative program fails on equal protection grounds. She sums up the court's majority opinion, perhaps in one of the most persuasive ways I've seen a justice do it. And she argues that the history of the Constitution is the history of the extension of constitutional rights and protections to people once ignored or excluded. VMI's story continues our comprehensive understanding of we the people being expanded. So an exceedingly persuasive opinion. And even more so when you consider the nature of where women's rights were before Justice Ginsburg began arguing before the Supreme Court in the 1970s. Interesting enough, Chief Justice Rehnquist actually concurs in the judgment. So he agrees with the outcome of the case. The only thing that he points out that he possibly disagrees with is that the exceedingly persuasive justification went beyond the traditional standard of important governmental interests in the intermediate level scrutiny test. This was the same important governmental interests that Justice Rehnquist lowered in his earlier opinions. So his disagreement with Rehnquist here is a disagreement that she raised a standard that he had previously lowered, which I find somewhat interesting. Remember, even in the first cases when he was on the court, he argued that gender-based laws need only come under rational basis. So there's an evolution here of a fair degree for Rehnquist, but that evolution, you can see him being pushed by Justice Ginsburg. Justice Scalia is the one dissent in the case. Again, as I said, 7-1 case. He basically says that he doesn't like the distinction being made between three different sorts of tests. So the rational basis test, the intermediate scrutiny test, and the strict scrutiny test. He writes that when a practice not expressly prohibited by the text of the Bill of Rights bears the endorsement of a long tradition of open, widespread, and unchallenged use that date back to the beginning of the Republic, we have no proper basis for striking it down. So since his basic argument, to sum it up, is that if it was not expressly prohibited in the Constitution and we've been doing it forever, that's not a good enough reason to justify ceasing its practice. So this is perhaps the most expansive articulation of women's protection of women's rights in the Supreme Court's history. And it's not the least bit shocking that that's coming from Justice Ginsburg, who at the beginning of her career was arguing before the Supreme Court on behalf of the ACLU, trying to carve out the distinction that the 14th Amendment also protected women's rights. And now in US v. Virginia, she writes very clearly that it does, and that protection, that intermediate scrutiny test that developed over time, should in actuality be much broader than how previous cases have cast it.